House Democrats have issued a subpoena to President Trump's personal attorney, Rudy Giuliani. They are seeking documents related to the president's July phone call with Ukraine's leader. But Giuliani has not committed to appear before the House. Natalie Brand reports from Capitol Hill.
President Trump's personal attorney, Rudy Giuliani, says he's still weighing whether to testify before House Democrats in the presidential impeachment inquiry.
I don't know if they let me use videotapes and tape recordings that I have.
A new subpoena sent to Giuliani Monday alleges he pressed the Ukrainian government to pursue two politically motivated investigations. One involves the 2016 campaign, and the other involves former Vice President Joe Biden, now a Democratic presidential frontrunner. In 2014, Biden's son Hunter joined the board of a Ukrainian natural gas company.
Who would pay him millions of dollars to go on a company that had to be reformed? They bought Joe Biden's office.
Ukraine's former top prosecutor has said there's no evidence of wrongdoing by the Bidens.
Giuliani is listed as a central figure in the whistleblower complaint publicly released late last week. Now House committees want all documents related to his dealings with Ukraine since President Trump's inauguration.
One of Giuliani's contacts mentioned in the subpoena is the mayor of Kiev. He spoke to CBS's Roxana Saberi.
So you've never spoken about the Bidens or election interference, anything about it?
Never, ever.
Saberi also spoke to a former Ukrainian lawmaker and former advisor to newly elected President Vladimir Zelensky, who says Giuliani tried to set up a meeting shortly after Zelensky's election this past spring.
I'm sure that issue of Biden was forever on the table between Zelensky and Trump.
Tuesday, Zelensky distanced himself from Giuliani.
I've never met Rudy Giuliani, never, and never had any phone calls with him.
Giuliani has denied any wrongdoing. Natalie Brand, CBS News, Capitol Hill.
Let's bring in now CBS News legal analyst Kim Wehle. Kim, thank you for being with us. We just heard Giuliani say he wants to use videotapes and recordings if he complies with House Democrats' subpoenas. Is that something Giuliani could be allowed to do?
I'm not aware of that process. Normally, the step one would be that Mr. Giuliani responds to the subpoena, gives that kind of information. If there are videos, would go then to the Congress, and then someone in the Congress, either individual members or a lawyer representing the Congress, as what happened with the Clinton impeachment process, would then question Mr. Giuliani, and the lawyer would decide whether to put that kind of information before the whole Congress and ask Mr. Giuliani about it. His lawyer could then have a rebuttal direct exam. In this moment, really, Mr. Giuliani should have his own lawyer because he's embroiled in a very serious situation. So he's not in a position to be setting the rules of the game with Congress. And the idea that he would go up there and sort of make his own speech using his videos, that would be quite unusual in any sort of legal proceeding.
Now, of course, he is the president's personal attorney. Could he then cite some sort of attorney-client privilege if he decides to testify?
Well, yeah, absolutely. Attorney-client privilege, though, is not as you suggest, is not a blanket privilege. People can't say, oh, attorney-client privilege, I'm not going to respond to the subpoena, I won't testify. Likewise, they can't say executive privilege, even though the White House has done that. That's not how privileges work. The way privileges work is that you would testify, you'd sit down, a question would be asked, and then your lawyer would object before you answer, and then say, that calls for privilege, I'm directing my client not to respond. And of course, as we saw with Michael Cohen, the only things that would be covered by a privilege with Mr. Giuliani, even though he's Mr. Trump's personal lawyer, would be confidential communications in order to give legal advice, so that nobody else can be in the room. And it would have to be for that purpose. It couldn't be for some other purpose that has nothing to do with actually getting information from a lawyer about the rights and obligations under the law. And my guess is there are conversations that go outside that scope as the judge or the individual magistrate decided in connection with reviewing Michael Cohen's documents. Most of that was not privileged.
And Kim, Secretary of State Mike Pompeo said he would not comply with subpoenas for documents related to the president's call with Ukraine, nor would he allow State Department officials to respond to depositions. He accused House Democrats of, quote, an attempt to intimidate, bully, and treat improperly the distinguished professionals of the Department of State. So, Kim, is there any legal basis for why Pompeo is ignoring these subpoenas?
Well, I certainly don't see it in that citation. The Congress does have, the Supreme Court's recognized it, has a constitutional prerogative to investigate. And the idea is if Congress can't investigate, they cannot legislate. It's part and parcel of their ability to legislate, to gather facts. Likewise, Congress cannot impeach if they can't investigate and gather information. So the subpoena is probably legitimate. There might be limits on the kind of information that can be turned over. We talked about executive privilege. There might be some state secrets, but this happened with the Nixon White House as well. Went all the way to the Supreme Court. That was for a trial subpoena, but the court said no. You got to turn over the tapes, and essentially, and that led to Mr. Nixon's eventual resignation. And essentially, what the law says in these instances is that the public's interest in having the information for purposes of a legitimate criminal proceeding in the criminal context, or I would say probably a court would say an impeachment because it's squarely the Congress is right under the Constitution. The public's right to know the information weighs heavily in this moment. And so that would be a significant, I think, consideration. I think it would be very, very difficult to quash all of these subpoenas. The issue really, though, is time. How long can the White House drag this out? But of course, there is also an opportunity for expedited review in the courts. You can ask for that.
Yeah, and so, Kim, as we know, the White House has defied subpoenas in the past. A lot has been stonewalled, by the White House. But I thought that officially announcing an impeachment inquiry was supposed to give House Democrats more power, sort of turbocharge these investigations when issuing subpoenas.
Tanya, that's a great question, because I've been a little baffled, frankly, as to why there haven't been motions to compel in the courts, basically to enforce Congress as an institution, its prerogative to actually serve these subpoenas. I don't really understand. I know the argument has been, well, there needs to be a legislative purpose. I think that's not a strong argument. There's not much precedent for that. So I was frankly surprised that the Congress hasn't pushed on that. It might be a political determination. But essentially the argument is now that we're in impeachment, you have it's turbocharged in terms of giving the court a rationale to force the State Department to comply. But the notion that this is somehow bullying, of course, that's just wrong. This is how our constitutional system works. The branches check each other, and that the reason they do it, the framers did it that way, is so we don't have a dictatorship. We don't have a monarchy that has unlimited power. And so that's the design.
And so, what are legal next steps then for these, congressional Democrats who are asking for these subpoenas as part of an impeachment inquiry?
So normally, step one would be to try to negotiate some kind of compromise. We saw this with Whitewater, with the deposition of President Clinton. They worked out a deal. They withdrew the subpoena. Ken Starr, my former boss, withdrew the subpoena in exchange for an agreement to not actually appear before the grand jury, to have limited questions, et cetera. So there could be a compromise for some of these. But we have such widespread, I think, subpoenas probably going forward, and then Mr. Pompeo's statement that he's just not going to comply. That might not work. Then this next step would be to go to court and file what's called a motion to compel, again invoking another branch of government to hold the executive branch accountable and say, listen, the law's on our side. Please issue an order and directing the State Department to turn over this information, because we have a prerogative under the Constitution to investigate. And then we would be in a moment potentially where Mr. Pompeo would say, I will comply with the court order, or I won't comply with the court order. If it's number two, we're even beyond what happened with Watergate. That's unprecedented, I think, and that would be in that level, and that would be a real constitutional crisis within a constitutional crisis, frankly.
Right. All right. Well, Kim, I have another legal question for you, and it has to do with the whistleblower's testimony. Republican Senator Chuck Grassley defended the integrity of the whistleblower in spite of the president's attempts to discredit him. In a statement, Grassley wrote, when it comes to whether someone qualifies as a whistleblower, the distinctions being drawn between first and second-hand knowledge are not legal ones. So, Kim, as our legal expert, is Grassley correct about that?
Grassley is absolutely correct about that. The whistleblower statute does not require firsthand knowledge, the idea that I actually witnessed it and saw it. That's not required. And it sort of makes sense. The idea behind the whistleblower statute is that sometimes, you know, government officials are going to hide information. People that work within government, and this happens in corporate America as well, people that work inside might have information that needs to come out in order to have a healthy organization. And oftentimes in the whistleblower context, that is hearsay. But the important thing to remember, the Inspector General came out recently saying, listen, this particular complaint wasn't based entirely on hearsay, which, by the way, is admissible in certain forms in court. Hearsay evidence isn't necessarily always bad. But in this instance, the Inspector General, who did the background sort of check on this whistleblower, found the whistleblower to be credible, found the matter to be of urgent concern, also said recently in a statement that he or she had firsthand knowledge. So Grassley's not only correct on the law, but factually, the premise that somehow the whistleblower is basing the complaint on second or third-hand knowledge is just factually incorrect.
Well, Kim Wehle, we thank you so much for sharing all of your legal expertise with us. We really appreciate it.
Thank you, Tanya.